I would like to call the meeting to order. Thank you, everyone, for being present, and looking forward to our discussion this afternoon. Lola and I are the co-chairs, and we talked this morning, agreed that I will be the leader of this call, and we will probably alternate in the future. And what we need to do first is just start off with a roll call to identify who's present, and just for informational purposes, since this is our first call together, we did this in the full committee. I'm not sure everybody was present, so just identify what you do in addition to your fact that you're present. So let's start with Solomon Ashby. Okay, Lola Perkins.
Here.
Good. Okay, what do you do, Lola?
Oh, I'm the county attorney in Surrey County.
Excellent. Good. Okay. Patrick Murphy.
I'm here, and I'm an attorney in the city attorney's office in Newport News.
Great. Jennifer Franklin, we think, is traveling.
I am here.
Oh,
it's
wonderful.
Late. I don't know how long I'll be able to stay on, but
okay. What are you doing here at home? Yes. Go ahead.
No, I'm still in Moldova. So
yes, that's what I thought.
10 p.m. I am from William and Mary. I'm a professor. I focus on appellate advocacy, academic success, and bar prep.
Okay. Thank you. Judge Ortiz.
Good afternoon. How are you all?
Great.
I'm here, and I am in Fairfax County, and I sit on the Court of Appeals. Did I answer the questions?
Yes, that does. Thank you very much. Okay. I'm David Newmeyer, and I'm Executive Director of Virginia Legal Aid Society, based in Lynchburg, as my day job. Henry Sue.
Here, and I am in Washington, D.C. I'm an adjunct professor at American University Washington College of Law.
Wonderful. Good. Okay, that concludes our roll call, and we do have a quorum for talking and for taking action, which is wonderful. And our agenda lists, pull that up. Okay, lists, I think, 8 substantive items, and we're going to start. Let's talk about guests. A principal guest is Janet. Would you introduce yourself?
Hey folks, I'm Janet Van Kirk. I'm the Deputy Executive Director with the Virginia State Bar, and here to talk about everyone's favorite topic, FOIA.
Yes, and I invite her. She did a terrific presentation for our OASIS subcommittee. I thought it would be valuable for us here. So, Janet, would you go ahead with that?
Great. I don't know if it's more intimidating to speak about FOIA before a former state's attorney general or a current member of the FOIA Council. So I am just going to wing it and then see what we have to add at the end of this. So I know a couple of questions have come up for folks relating to both, well, particularly to meetings, but as you guys know, FOIA is our open government statute here in Virginia. And we love open government because it gives sunlight in to let the public know what we're doing. And we're doing, except for with the bar, we're doing it with bar money, but everyone else is doing it with taxpayer funds. So for you folks, FOIA comes into play in 2 parts. First is documents. Everything from this committee is subject to FOIA. So the notes you are taking right now saying, you know, David is wearing a checked shirt, that is subject to FOIA. Any member of the public could contact us and say, I want your notes from today's meetings. They could also request any of like the transcripts when we do them through Teams, and any work product that you have even included in draft form. This applies to committees and subcommittees and study committees of all public bodies, and the Virginia State Bar is a public body. What you should worry about is if a member of the public gets in touch with you and asks for your documents, pretty much all you have to do is call Chris or me, and we will walk you through what you need to do in order to respond, and we will be doing the response for you. The most important part of that is just let us know ASAP if you are contacted by a member of the public who wants documents relating to this committee, because the statute requires the agency to respond within 5 days, and that starts the day after that person makes that request. And it's after that person makes the request to you guys. It doesn't have to filter all the way to the FOIA officer in order for that time frame to start ticking. There's an ability to get an exception. We try to get in under the 5-day rule. We're not doing a great job this weekend getting to that, but we're working on it. So just FYI, things that you write, things that if you do audio recordings, your emails, everything is considered a document regardless of what form it is in for the purposes of FOIA. For meetings, I can't imagine having to figure out how to get a in-person quorum if the quorum were a majority. The first thing I did when I started here was to change our bylaws and change our bylaws quorum to 3. So we have a quorum of 3 requirement unless there is a committee of 3 people, in which case the quorum is 2. That doesn't apply to you folks. FOIA is silent on quorum. So that's why it defers to our bylaws on that. But you do have to have a quorum present in order to conduct business. And under our bylaws, you have to have a majority of the full membership in order to take action on behalf of the committee. You have to have a vote of a majority. So if you have 9 people in your committee and you have 5 people present and only 4 of them vote in favor of an action, that is not sufficient to pass it under our bylaws. You have to have a majority of the full body of 9, so it has to be 5. Meeting and notice are the big things that come from the FOIA requirements. So you have to do meetings notice 3 days prior to the holding of a business meeting subject to FOIA. Just let Chris know when they are scheduled. We post them on our calendar, on the Commonwealth calendar, at our front desk, and elsewhere as required under the statute. Included in that meeting is by the means by which you are holding that meeting and how the public can participate in that. For your meetings, there is the ability to do all virtual, as you guys are benefiting from today, but that is limited in the statute. Currently, it is limited in the statute to 2 meetings per calendar year, and no 2 can be consecutively held. That will change on July 1st. Will it be 50% per calendar year and no 2 consecutively can be held? And so you guys will have the benefit of that, knowing that in the interim, you cannot have 2 all virtual meetings together. When you are holding an all virtual meeting, you did not have to say where you are calling from, but you do have to follow all the other requirements in having the public have accessibility into the meeting and a phone number that they can call if they have technical trouble. Aside from that, you can also, on the in-person meetings, that's every other meeting, it can be either fully in person, so all 9 members of the committee would be in the same place at the same time without the allowance of virtual participation, in which case the public is you're not required to have a virtual stream for the public. But any meeting that you're having hybrid format, you have to have your quorum of 3 assembled in one space together, and that space has to be open to the public. So if you guys are meeting in a public library, just make sure that the librarian at the front desk knows where you are. You can't be squirreled away where they can't find the meeting. It has to be accessible to the public, and they have to know where to find you. Chris will take care of the notifications for all of that stuff. And then anyone else can join in to that meeting from the committee, making the full quorum. Accidental meetings happen all the time. That's the rule of 3. That is the reason we set the quorum requirement at 3 in our bylaws. 2 members of this group can talk all you want about the business of this group. 3 members of this group, unless it is a noticed meeting, following the notice, the minutes, the public access requirements, you cannot discuss the business of this group. 3 members makes a meeting. Having a meeting of 3 people where you're discussing it, even if it's accidental, is in violation of FOIA, and someone can claim that against us in court. How you avoid that is when you're together, so all 3 of you guys can go to the same CLE together, talk about the CLE, just don't talk about the public business. Or 2 of you talk about it, 2 of you talk about it, 2 of you talk about it, but please don't have 3 of you folks together having a conversation regarding the business. Email is another place where we have accidental meetings. Accidental meetings happen by email when you have the contemporaneous exchange of information, a dialogue between people, between 3 people, 3 or more people in the committee. So 2 of you can email back and forth all day, every nanosecond if you are interested in being that fast, which would be impressive in your typing skills. 3 of you cannot. You can share information to 3 members of the committee or the full committee. You cannot have a contemporaneous exchange. Case law is a little split on that, on what it looks like. They've held that a 2-hour interval in between does not constitute a public meeting when you're having that email exchange. So post information, wait a while, someone else can post information to share back, but you can't have it go back and forth. And that's still a little nebulous on what are actually the parameters around how frequently you can do it. Regarding scheduling of the meetings, we're going to put in place doing a doodle poll. You can all submit information one direction to the same person. It is the back and forth that is the problem. And then what else on emails? Did I miss anything, Chris? All right. So in-person meetings, every other meeting, make sure you have a quorum in the place where people can get to and they know about it. Every other one you'll be able to after July 1st, have that all virtual. Just make sure that this means is ability for them to get in. And if you have any documents and anyone contacts you about it, just let us know. And that is FOIA 101 for you guys. Any questions? Come on, Lola.
Oh, well, since you've opened the door, I did want to bring up, because, you know, Patrick and I had actually been emailing, because, you know, I was not in a FOIA mind frame. I was like, oh, this is the committee I'm helping with. I wasn't wearing my FOIA hat. And Patrick very astutely was like, Lola, FOIA. So the way I kind of justified this one is this is a special meeting. This is our organizational meeting, which does not require 3 days notice. Now, obviously, we can't do that every single time, but if we were to get in a pickle, I think that's legally defensible.
Correct. So special meeting is basically the non-routine meeting of the public body. Here, since you guys were sort of ad hocing putting this together, we classified it as that meeting. The requirement in FOIA when you have a special meeting is that when members of the public body are given notice that the meeting is going to happen, that also has to be made accessible to the public. So when you schedule this, Chris was over with our communications folks, making sure that that was all published on the website. Regularly scheduled business meetings have to have the 3-day in advance. It's only when something pops up, either an emergency or a special meeting, where the 3 days is not applicable. And even then, there is the contemporaneous when the members know of the date, you have to let the public know that.
And one practical consideration, because this came up with us, Lola, because we would have been within that 3-day time frame had we posted it on the day that you'd emailed me. But you emailed me at 4:50. And for those of you all that don't know, our office closes at 4:45, which is a little funky. So our communications people who are responsible for posting are typically not here at 4:50. So we just couldn't post it because I didn't have access. So just something to keep in mind, that our office hours are a little funky compared to regular business hours.
Great to know.
Janet, when you were mentioning the 2-hour delay for responding substantively to an email, I had an image of a pitch clock in baseball, which, you know, there's a big clock, you know, on the outfield wall now. So everybody knows what the time remaining is. And thinking to myself, gee, if our email could only have like a little clock embedded, we would know when we could respond to it.
Yeah.
Could you work on that?
Sorry. And on the polling, you can poll to get people's opinions on stuff and what you think the recommendation is. Just a reminder that all voting also has to be at a public meeting. And I think that's it. Have fun with FOIA. It's a blast.
Really? Okay, good. Any other questions for Janet? Okay, Janet, thank you very much for the presentation.
All right, enjoy your afternoon.
Good, okay. All right, we are next going through a quick review of the mission statements. And so this is a time to remind us that this is a meeting of the legal subcommittee. I'm still trying to memorize which committee is which, because I've been running them together so easily. So what we are studying, and I'll just read the mission statement out loud. To examine and raise awareness of the declining number of lawyers practicing in Virginia, resulting impacts on the population and economy of the Commonwealth, particularly in geographic areas that may be described as legal deserts, and to make recommendations to address those trends, mitigate adverse impacts, and improve access to legal services, the legal profession, and justice systems for all Virginians. And whoever's typing, if you could mute yourself, that would be great. Good. Any question or comments on the mission statement? Next up then is discussion of our what I'd like to go through next is the scope of work and talk about the information gathering and how we're going to organize that. We have an ambitious schedule of a little less than a year to examine a lot of the legal universe, I think. We're going to be looking at trends in the Virginia lawyer population to better understand demographics and legal practice areas of VSB members. The legal desert definition, I think that will be our OASIS subcommittee that will be looking at that, and we don't have to focus on that. I think this is a subsidiary consideration, I think, to analyze, determine how best to publicize VSB membership information and related trends to the membership and to the justice system. Develop accessible and ready implementable recommendations to grow the population of Virginia attorneys statewide and its underserved locations, including ways to attract and retain Virginia lawyers to work in at-risk geographic areas. Again, that's more focused on the OASIS committee. Identify regulatory reforms, legislative actions, and other potential solutions to increase attorney numbers and mitigate the impacts of legal deserts. Well, there we are, OASIS again, and refer to its stakeholder groups to develop and implementation as possible. There are a number of stakeholders that we can potentially contact and work with to gather information and recommendations. And there's our list here includes the law schools, the Board of Bar Examiners, the ABA, law students, which I think would be valuable, via the VSB membership groups, membership classes, the Access to Justice Commission, the Virginia Bar Association, and other states. And particularly, I think valuable would be programs and initiatives that they've undertaken to admission interest in practicing in their states. And then our options include to invite guests to meetings to help guide us, and that might include the State Bar staff to present on membership information, other guest speakers, a survey that we might want to conduct to State Bar members to gather additional information, surveys or outreach to other states to learn about their programs, and law school statistics going back to 10 to 20 years, conduct law student focus groups, strategic outreach to the bar examiners and ABAs as appropriate, developing maps and infographics. And just as an example of I think some of the thinking that's been going on this morning, we had a brief meeting. Chris, Lola, and I had an online meeting with the operations director and general counsel of the Indigent Defense Commission regarding the declining number of people taking the bar exam in Virginia compared with other states, and with particular attention to whether the states have adopted the uniform bar exam. And it looks, we our application rates to take the exam have plummeted in Virginia. Other states that have adopted the uniform bar exam appear to have stabilized their rates of taking the exam, and in some cases actually increased the number of attorneys taking it. So we are going to invite him to speak to us in person as well. So any comments about the scope of our work and information gathering, and how we go about doing that? In our other OASIS group, Chris suggested, I think, creating a matrix for people to volunteer for various tasks. So for the tasks that we need to accomplish, we know we have at least one volunteer for each of them, and we could have potentially another as well. So I open the floor.
I like the idea of setting up a matrix, and that way folks can take some time to think about which they would like to sign up for, and a little bit of time, not a ton of time, because we're on a tight turnaround. But I like that. I like that approach instead of taking time from our meetings to get volunteers.
Me too.
I wanted to also mention that the chairs are going to be having a meeting in mid-June. And so my hope is that I'll have those matrices drafted and circulated and get signups, so that then at the chairs meeting, we can look at it and make sure we're not missing anything, make sure the signups make sense and that everything's covered. But I think, David and Bruce, you all are asking every member of the OASIS subcommittee to sign up for at least one line item on the matrix, correct?
Yes, exactly.
Okay. One other thing that the matrix will allow us to do is that, in particular for this subcommittee, there's a lot of work that has already been done by stakeholder partners and by the Virginia State Bar, honestly, just because we've been looking at the overall attorney trends in terms of new attorneys that are becoming members of the Virginia State Bar. There's been outreach by Janet already to the law schools to get their graduation rates, employment information, and bar examination information. I think we may ask Janet to expand that to include the admissions information. And then we talked this morning with Amari about potential sources for getting information, like how many Virginia law students are in state, how many are out of state, and then seeing if we could gather that for the surrounding UBE states as well, just to sort of see if there's any trends, like people who already live in that state or go to law school in that state, do they tend to stay in that state, particularly if it is a UBE state? Or at least do they take that state's bar exam, to see if we can kind of pin down and differentiate Virginia from some of our bordering states, at least up to New York, I think, because that does draw a lot of attorneys as well. So all that hopefully will be kind of mapped out in this matrix, and then I can fill in the process of collecting this, or have already collected this, and then we'll kind of know where the fingers need to go out to gather more.
Right. Henry, you've done some writing on this subject, I think. Have we've left anything out of our discussion so far?
I mean, I think, you know, this kind of work is interesting. I think, to follow up on what Chris was saying, you know, one thing to definitely look at is for the folks who are practicing in the DMV, you know, what bar do they choose to take? Are they sitting for DC or Maryland or Virginia, and why? So, you know.
And I think one of the great things about that, Henry, is that the Virginia State Bar used to assign a non-geographical circuit to our associate members. So
Mhm.
they were essentially circuit 0, right? Which is meaningless. It's not actually connected to a geographic area inside or out of the state. We don't do that anymore. All of our associate members are now also assigned a geographic circuit. So we know if they're sitting in the state or sitting out of the state. So we could definitely look at people in the Northern Virginia circuits and then associate members who are 33 out of state to poll them or survey them. I really do think that surveying, especially within this group, is going to be particularly critical. And I think that we can include law students in the surveying, but it might make sense for us to kind of in parallel with what the OASIS subcommittee is doing, maybe have like some field hearings at the law schools. Or even if we could do virtual focus groups where the law school contacts help pull in some 3Ls, you know, that have already made their decision about where they're going to be taking the bar exam, so we can kind of hear not just about the bar exam, but their perceptions about Virginia practice generally. One of the things that we learned at our strategic planning retreat was that there is a lot of confusion between the Virginia State Bar and the Virginia Board of Bar Examiners, and people think we're the same, or that they're at least a subset of us, and we're not. We're completely different. And it's very interesting that they control all aspects of admissions, and then we control all aspects of membership, right? But we have no control over the flow of attorneys into the Virginia State Bar. So, you know, all those things I think are just sort of like level setting considerations to think about. And I'll turn it back over to members, but thought that was worth raising.
I mean, Jennifer has her hand up.
I do. I thought I might just weigh in really quickly, and please don't shoot the messenger in my messaging to you all, or in the messaging that, you know, I know that we do at William and Mary with our law students. But the reality is that if a law student is planning to work in the Delmarva area and they take the Virginia bar first, they have to take a full second bar if they want to be barred in both locations within a period, you know, a short period of time. But if they take the UBE jurisdiction first, then they can take just the Virginia section in February. And so, right, I mean, it's the recommendation that if you're working in DC or Maryland, and sometimes even Northern Virginia, that UBE is the way to go first. And you know, I'm speculating, but I'm pretty sure that ultimately it's affecting numbers, because the reality is that the bigger firms in DC and Maryland, there's probably not a lot of Virginia specific practice that's happening within those first few years. And I think that new associates are then, after having undergone the bar process and knowing that they can be barred in DC, Maryland, Pennsylvania, New Jersey, and New York, right? That they're just choosing not to pursue the Virginia licensure afterwards. And I mean, I know that, I mean, I am a big proponent of Virginia and, you know, being a Virginia attorney, but it just doesn't make sense to do it the other way around.
And for me, I mean, that's good to know, because I'm not tuned in, you know, right now to kind of that decision making for the graduates that we're seeing now.
And I recognize too, and something we really need to think about when we talk about UBE, that has a limited shelf life, and we need to keep that in mind, that the UBE will go away. By 2028 will be the last year that the UBE will be offered. Even in 2026, so this year's first year class, our entering class, when they graduate, if they go to Maryland, they'll be taking the next gen bar exam. And after 2028, no component of the UBE, including the MBE that our Virginia Board of Bar Examiners relies on, will be available to anybody, including Virginia. If they choose not to go next gen, the Virginia Board of Bar Examiners will have to create its own, completely its own bar, including the multiple choice.
Can I ask you, Jennifer, to just give us a quick primer on next gen and what it has in common with the UBE and what it doesn't?
Sure. So the next gen bar exam is designed to make the bar a little more accessible to students, try to kind of even the playing field in response to, you know, the contention that the bar exam, right, is unduly unfair to underrepresented subsections of the community. And so what the National Conference of Bar Examiners is doing is they are breaking it down into 3 subparts. So right now the uniform bar exam has the traditional MBE, the multiple choice that we know. It has, 6 essays that are very similar to, what we do in Virginia, but without the Virginia specific component, and 2 what they call multi-state performance tests, which are a fact pattern and a library of legal documents. So cases, statutes, anything you might need. And the idea is you don't have to come in with any pre-knowledge. You use the materials you were given in much the same way, if you guys remember, like if you had a first year legal writing class, writing an objective memo or writing your first persuasive memo, focusing usually on the discussion section of that. And so what they're going to do, instead of having these 3 separate components, they're first going to break it down from being 4 3-hour sections to 3 3-hour sections. So 2 on the first day, 1 on the second day. And what they've said is the reason for going with 1 on the second day is because some of the jurisdictions that historically do not offer the UBE, like Florida, Georgia, Virginia, that there will perhaps do the 3 sections and then do the state specific component in the afternoon or the second day. Okay. And in each of the 3 sections, instead of breaking it up and doing all multiple choice, all essay, all MPT, each 3-hour section is going to have multiple choice. The essays are being replaced with kind of like a slightly longer fact pattern with multiple questions where things can change along the way, and to kind of judge how the student can pivot, that sort of thing. And then an MPT. So each 3-hour block will have all components of the next gen bar exam, and it will test more skill ready things such as you were talking to a person who has been charged with a misdemeanor crime, or they had previously been convicted of a misdemeanor for X. They want to testify. How do you advise them? And there's usually, if there's 4 choices, you get one correct answer. If there's 6 choices, there are 2 possible correct answers. You pick the 2 best. And there are things like, you tell them absolutely they cannot testify, which is obviously wrong. Absolutely they must testify, which is also wrong. You advise them that they should testify or that they may not wish to testify. I'm not a big fan of these yet, but they're designed to test the skills that we utilize when we're practicing.
And is it portable like the UBE in the sense that you can take it in one state and then depending on your score, get admitted in states that have signed on?
Yes.
How does that part of it? Okay, all right.
Yes, and for the meantime, so in 2026, Maryland and one other state is offering it. 2027, there's I think 8 to 10 states are adding it. 2028, probably we'll see most of the other states add it at that time. After 2028, you're either using it or you're creating your own. And in the meantime, the National Conference of Bar Examiners is pushing, and most of the jurisdictions have been amenable to, if you take next gen in Maryland, for instance, you will still have that ability to seek admission to DC if you get a passing score. That's still a little bit up in the air because, of course, right, the passing scores for the next gen are going to be slightly different than the UBE administration.
Something that intrigues me is the movement toward, I think it's called admission by privilege. Simply, yes, getting a degree from a law school, an accredited law school, and I assume there's some minimum grade point average or something like that, would be enough to qualify for admission.
Right. Well, and some of those are not pure admission to privilege. Like Oregon's, for instance, you're going to have to, once you've graduated from law school, you are going to have to do some sort of an apprenticeship before you can get admission, where you essentially create a portfolio of your work that gets submitted to the bar for review.
Interesting.
Yeah.
That's reminiscent of the Canadian articling system, where for a year after you graduate, yes, you're doing basically an internship. Cool. Okay. And to get really wild, there are states like Alaska that are experimenting with using non-attorneys to represent clients in court on very limited areas such as landlord, tenant, or child custody, where the paralegals are trained and supervised by the legal aid program. And I think we need to be at least learn what's going on in each of those so we know how to respond. There is a subcommittee of the Access to Justice Commission of Virginia that is also looking at non-lawyer legal assistance, and I think we can borrow what they develop.
David, I did want to raise, I was on the ABA's Legal Desert call, like the Greening Legal Deserts webinar, the first one, not the one that I forwarded to the group recently that's coming up in June. And they were talking a lot about this concept of the community justice workers. And I love the idea that they're located in the communities already and connected to the populations that are most likely to be in need of the legal services that would be most appropriate for this type of engagement. And one thing that I thought of, and I didn't really have a chance to ask, was whether or not any state had explored the idea of utilizing that model as a pipeline to law school. So like essentially, you become a community justice worker in your community. And if you do it for X number of years, like you're basically guaranteed that you're going to get into your regional law school. And then that to me would be a good way to sort of seed the soil for legal desert issues down the road. And it might actually be an incentive too for those community justice workers to consider becoming attorneys. So I don't know, that's just something I wanted to float out there. That might be something for like a reconvened study committee to look at after the commission's committee has made a recommendation and maybe we see that start in Virginia. But I think those are the sort of creative pipeline ideas that we need to sort of just kind of keep in the back of our mind.
Absolutely.
One thing I'll just say about Alaska is, they don't have a law school. And so that's a challenge in of itself.
Interesting. Good. Yeah. Good. Yeah, I agree. We need to have everything on the table. Thank you, Chris. Okay. I have another call scheduled at 4, so I'd like to move through the rest of the agenda, particularly identify our next meeting date or the schedule that we're looking at. And what did I just do with that? So for our subcommittee, what we need to do before the July 10th meeting of the full committee is develop our initial research plan with proposed dates for meetings and any hearings that we want to organize. Lola and I've talked about whether doing a hearing in Richmond might be useful. Research, data, stakeholders that we want to contact. These are all things that will be covered in Chris's matrix. Before the December 2024 study committee meeting, we will have drafted research findings and agreed on directions for our content and drafting assignments, and a drafting timeline. Before the full committee of March 2025, we will have an initial draft completed of our report with recommendations and related graphics, and identify anything that's unfinished or outside the work of the scope of our work, and then have a final report by the full committee before the May meeting of the full committee. So we will have to keep our nose to the grindstone, I think, to meet all those. Okay, any comments? Items we should consider on this call today that we haven't touched on already? Okay. Did someone have, was that a throat clearing or something else? I heard a noise. Okay, never mind. No noise. Good. Welcome everyone's thoughts at any time on speakers we should consider, other things we should bring in. We can use this folder, the SharePoint folder set up and distributed by Christy for this meeting, as a repository for everything we find. And I think it will be useful for all of us to do that, so we could go back and find resources. I think the folder will be publicly visible from the VSB websites, and so just keep in mind that the public will be able to find those things too if they look. But I'm fine with everything, making everything available. To me, there's no such thing as bad information. Okay. If there are no other comments, I think we're done for today. I want to ask Chris and Lola to stay on for a minute. And thank you all very much for taking part in this. We'll look forward to seeing Chris's matrix next, which Lola and I will assist on, and we'll get started.
David, did you want to poll the group for the next meeting date? I know the OASIS subcommittee decided that they definitely needed to meet again prior to the July 10th. Do you think the same thing is going to happen here? You think we're going to have to kind of look at that matrix and sign off on it before we present it to the full committee on July 10th?
Yeah, certainly. I think that would be useful. And Chris, I can't remember what date we chose. How late in this before the next full committee meeting do we want to do that?
The next full committee meeting is July 10th.
Yeah.
Our chairs meeting is the week of June 10th. So I'll probably poll this group for availability in the last part of June.
Okay. Good. Sounds good to me.
Okay. And the one other thing I wanted to put on people's radars, especially if you're doing out-of-state research, is potentially looking at the breadth of their reciprocity rules, because that is another area where we could potentially bring attorneys into Virginia. Just by way of example, I've had multiple individuals affiliated with Legal Aid, either as volunteers or as part-time staff, say they really would love to become a Virginia attorney. They don't want to take another bar exam, particularly not the Virginia bar exam. And they've been practicing for years, but it's been part-time, because they're a primary caregiver to a parent or a child, or they're doing other work in the community in addition to practicing law, and they're just automatically precluded under our rule because it does have a full-time practice of law requirement. So looking at things like that might also be worthwhile.
Chris, I'm so glad you brought that up because I had been thinking that same thing. That the distinction between the different states' reciprocity rules might be impacting things. I hadn't thought about the part-time aspect of it. And the other thing I'll throw out there, I mentioned this to David the other day when he and I spoke, half jokingly, half truthfully. Does Virginia still require you to dress up when you take the bar exam? Because do away with that, and I think you'd get more people.
Yeah. That's the whole like sort of branding of Virginia practice that I think is a problem, because we are so closely associated with the Virginia Board of Bar Examiners, and they have some funky old Virginia ways, right? So we may need to talk about, like, make recommendations around just sort of clarifying that relationship, at the very least, particularly to law students.
Indeed. Thank you, Lola.
So thank you for indulging me, David. I just wanted to make sure.
Yeah, no, I'm glad
mention
you brought that up, Chris. I think it's very important. Good. Okay, thank you, everybody. Lola and Chris and I are going to stay on for another minute.
Thank you very much.
Thank you. Okay, I just want to see any other comments, whatever.
I don't think so.
Just that it sounds like we need to notice our chairs meeting.
Yes, we will.
Mm.
Yes. And actually, I was almost going to raise it with Janet, but I didn't want to take the committee's time. I'm going to get her input on whether we can sort of treat the chairs as like a separate group that is, you know, on its own meeting schedule. Because I think it will be helpful for us to do that and just sort of touch base every once in a while as a group.
Absolutely.
You know, just to make sure that we're all in the same page and that we're thinking strategically at every point in the process. So as long as it doesn't impact, you know, the meetings and the consecutive all virtual for the other groups, then I think that would work really well.
Yeah.
Great. Good. Okay. Thank you both. Have a great weekend.
Thank you.
And,
all of you as well.
Yeah.
Safe travels again, Bruce. And yeah, I guess we'll reconnect. Do we have any? I know David and I had talked about some homework that we have, but Chris, from your perspective, do we as chairs have any homework that we need to take care of before our chairs meeting?
I mean, if you want to look through this document with a fine-tooth comb and add to it if you need to, then I can pull that in when I'm drafting the matrix. I will definitely get that to you all before our meeting the week of June 10th. But we've got our annual meeting next week, and then I'm on vacation for a week the week after. So it may not be until that week of the call that I get it to you. But that means that you have plenty of time to go into here and add sub bullets or thoughts or comments that I can pull into the matrix. So if you want to do that, that'd be great. But I see the formal homework being with me.
Perfect. Okay.
All right. Well, Chris, be sure we don't expect you to carry all the water here, and Lola and I will certainly do a lot with you. But yeah, keep us informed of what you need.
Absolutely. Yes. Yeah. Thank y'all so much. It's an exciting group to be a part of. This is really important work. So
yeah.
We wouldn't be able to do it without you.
Okay. Thank you.
Bye. Good night.
Have a great weekend. Bye.